New Hampshire has a lightly regulated breaking lease framework with few state-level restrictions beyond the federal baseline, consistent with the state's overall libertarian approach to government regulation. The governing law is found in New Hampshire Revised Statutes, Chapter 540 and Chapter 540 IA, which cover landlord and tenant relations, along with general contract principles. If you're a landlord or tenant in New Hampshire, the limited statutory framework means the lease agreement is your primary governing document for early termination. Let's start with the landlord's duty to mitigate damages. New Hampshire recognizes the landlord's duty to mitigate through case law and general contract principles. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit empty and collect the full remaining rent from the departing tenant. The landlord must take reasonable steps, advertising, showing, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced accordingly. Early termination clauses are generally enforceable in New Hampshire. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. The fee must be reasonable. A grossly excessive fee could be challenged as an unenforceable penalty. Military members have the right to break a lease under the SCRA. New Hampshire's military presence is relatively limited. The New Hampshire National Guard and the Portsmouth Naval Shipyard across the border in Kittery. Maine are the primary military connections. Service members renting in New Hampshire have full SCRA protections. New Hampshire does not have a specific state statute providing enhanced lease-breaking protections for victims of domestic violence in the detailed framework found in more regulated states. Victims must rely on general contract principles or negotiate with the landlord. Tenants may break a lease if the landlord fails to maintain habitable conditions. New Hampshire recognizes an implied warranty of habitability. If the landlord fails to address serious health and safety issues after receiving proper notice, the tenant may have grounds for lease termination based on constructive eviction. From a practical standpoint, New Hampshire's rental market is shaped by proximity to Massachusetts. Southern New Hampshire, Nashua, Manchester, Salem, functions as an extension of the greater Boston market with strong demand and relatively quick re-rental. Portsmouth and the Seacoast have a tight market. Concord has a stable government-driven market. The Upper Valley near Dartmouth has strong demand. Northern New Hampshire has softer markets, where re-rental takes longer. One best practice, given New Hampshire's extremely low security deposit cap of 1 month's rent, treat prompt re-rental as your primary financial protection when a tenant breaks the lease. Begin marketing immediately and document all efforts. Another best practice, include a clear early termination clause in every lease. New Hampshire's limited statutory framework makes the lease your primary document. A well-drafted clause prevents disputes. New Hampshire limits the security deposit to 1 month's rent or $100, whichever is greater. The deposit must be returned within 30 days. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to New Hampshire breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.